and I'd like to call this meeting to order. Thank you all for coming here tonight. The Eugene Planning Commission will be holding, as you all know, I hope you're here in the right place, holding a public hearing on an appeal of the hearings official's approval with conditions of a tentative planned unit development, City File PDT 18-4, known as Braywood Hills PUD, 3rd edition, phases 5 and 6. My name is Kristen Taylor. I'm the chair of the Eugene Planning Commission. And to start, I'd like to have the planning commissioners introduce themselves. And why don't I start with you?
John Borofsky, Commissioner.
Tiffany Edwards, Vice Chair.
Lisa Fragola, Commissioner.
Stephen Baker, Commissioner.
And we also have the following staff present, and I'm just going to have each of you introduce yourselves.
Nick Troiello, Associate Planner.
Lauren Summers, Assistant City Attorney.
Alyssa Hansen with the Planning Division. And this is Janessa Dragovich with Building and Permit Services.
Great. I went off script a little bit. I was supposed to announce, but I think it's nice for you to hear their voices, get to know them, if you don't already know them. I'd like to take a moment to explain who the Planning Commission is and our role. And right now, I'm going to read from the script to make sure I cover everything. So, you know, it might get a little rote. We are unpaid volunteers appointed by the Eugene City Council to a 4-year terms on the commission. We all live and work in Eugene, like many of you. We directly advise our city council on matters related to land use, and we are also tasked with making certain land use decisions on behalf of the city. We're responsible for upholding the laws of our city and our state, the policies of our city council, and of course, at the same time, we're also responsible to everyone who lives and works in Eugene. We're at-large members, which means we have to consider the needs of the community as a whole, as well as the needs of all groups and neighborhoods. We're also human beings, which means each one of us has personal views that make us who we are. But as planning commissioners, we're committed to balancing all of our needs as a community and to make the best decisions we possibly can based on our policies and our laws. We strive to sort through all the evidence and facts presented and carefully review the pertinent code criteria to make thoroughly informed and unbiased decisions as a governing body. This can be pretty tough to do, and we know that not everyone will agree with every decision we make, but we try to make these hard decisions through careful deliberation and to the best of our abilities. The Planning Commission's role in this appeal process is to affirm, reverse, or modify the hearing's official decision conditionally approving the PUD application. Tonight, we will listen to what the applicant and the public have to say. We will not take action tonight. We will deliberate and take action on this appeal on June 24th and 25th, and I'll repeat those dates later. You are welcome to attend those meetings or to watch them on the city's website. As we proceed tonight, we will want the public to know that we will listen carefully and hear your concerns about this appeal. Even though we may not ultimately make the decision you would prefer, know that you will be heard and that we will strive to make the best decision possible. The decision of the Planning Commission on this appeal is considered a quasi-judicial decision. This means we are legally required to have a certain order of speakers, and there are specific rules or criteria that our decision must be based upon. First, we'll begin with a brief presentation from staff and then open the public hearing. If anyone in the audience would like to speak, if you haven't done so already, there are some green slips, and I don't know if they're still at the back counter or if staff has them. They're still at the back counter, so go to the back counter and fill out the form and bring it forward to staff here at the table. Once the public hearing is open, speakers will be called in the following order. 1, the applicant and those in support of the application. 2, those with a neutral position. And 3, those opposed to the application. The commission will then ask for staff response to testimony, and finally, the applicant will have the opportunity to present a final rebuttal. During this process, the Planning Commission may ask questions of anyone who provides public testimony. So we'll just, after your testimony, we'll ask questions, if applicable. The Planning Commission's decision will be the final city decision on this matter. Any appeals of the Planning Commission's decision must be filed with the State Land Use Board of Appeals. The purpose of tonight's hearing is to receive relevant testimony on the appeal before us. I want to remind everyone that your testimony must be directed toward the issues identified in the appeal statement and the applicable approval criteria from the Eugene Code. And this is a really important piece, is that no new evidence can be accepted by the Planning Commission, and we can only accept argument related to evidence that is already in the record. So please keep that in mind. If you have any questions, you can ask staff before you speak. What this means is that you should be speaking about, 1, the materials and information already presented to the hearings official in the first public hearing process. 2, whether or not you think the hearings official made a mistake based on the approval criteria for the tentative PUD and the evidence that she had at the time. I want to remind everyone that the failure to raise an issue with sufficient specificity to allow the Planning Commission and parties to respond will preclude future appeals on that issue. So make sure you're very clear. In other words, now is your opportunity to raise issues as clearly as you can so that the city and other parties can address them. Before we begin, the Eugene Code also requires that planning commissioners disclose any conflicts of interest, ex parte contacts, biases, or abstentions. In quasi-judicial proceeding like this one, the parties are entitled to an impartial or neutral decision maker. To ensure this fair consideration, the Eugene Code and the Planning Commission's rules attempt to limit ex parte contacts or communications between a party and the decision maker outside the public hearing process. Each planning commissioner must disclose and describe the substance of any communication they have had about this application outside the public process. The planning commissioners must also disclose any conflicts of interest. That is, whether the decision they are about to make could or would result in a personal financial gain to themselves, their businesses, or a member of their household. Finally, a planning commissioner cannot participate if he or she is biased. That is, for whatever reason, he or she is incapable of making an impartial decision on this appeal based on the evidence and arguments in the record. Do any commissioners have conflict of interest, bias, or ex parte contacts to disclose? Okay. Have staff received any challenges to a commissioner's impartiality submitted pursuant to Eugene Code Section 9.7065, subsection 5?
No.
Okay, great. So we'll begin with a brief presentation from staff. Nicholas Giello from the Planning Division will speak about the application on appeal. And then Lauren Summers might add something.
Thank you. My name is Nicholas Gioiello, Associate Planner with the City of Eugene Planning Department. To my left is Lauren Summers from the City Attorney's Office. Lisa Hansen from the Planning Department. She's our Principal Planner. And Janessa Dragovich, I'm having one of those senior moments. Janessa Dragovich, also from the Planning Department. We're here tonight for the Braywood Hills 3rd Edition Phases 5 and 6 PUD, and this is an appeal of an approval that was done through a hearings official action. There we go. So I'm going to give you just a brief overview for everybody. Subject property is outlined here in yellow on the, and it is approximately 15.47 acres, and it abuts the east side of Hawkins Lane and also Randy Lane. The site around it is generally developed with single-family homes and mostly a public street system. Vedera Park is abutting the property along the southern boundary. And I'm going to try to point that out here just a second. There we go. Right in this area is Vedera Park. How does that look? Okay. That's pretty cool. The site itself is zoned R1 low-density residential with a PD planned unit development and WR Water Resources Conservation Overlay zoning districts on it. And the applicant came in and applied for a PUD under the needed housing approval criteria to create a 36-lot residential subdivision with private streets and associated infrastructure. In the agenda item summary that we prepared for you for this meeting tonight, we mentioned that the hearings official approved this application, and we said subject to 34 conditions, and that is an error. It was actually 16 conditions. Just wanted to make that clear for the record. And so tonight we're here, and here's a layout of the entire property and proposed 36 lots and street system. I'm going to point out a few things. The green colored area that you see here bordering the property is the required 30-foot conservation or buffer area that needed housing criteria requires. And then the areas that you see here in yellow throughout this site that I'm putting the pointer on, all of those areas were deemed to be greater than or equal to or greater than 20% slopes. So you can see a significant portion of this site has a lot of slope to it. Just for reference, this is Hawkins Lane right here, and then Randy Lane that's currently developed comes to this point right here. And then the applicant is proposing to expand with street into here and bring Randy Lane down to this area. So after the hearing's official approval, the applicant filed an appeal and basically listed 4 areas of appeal, and I'm going to go through them. It doesn't sound like much when you say there's 4 appeal issues, but within some of these appeal issues, there's sub-issues that makes it kind of complex. I'm going to try to walk everyone through it, and hopefully we'll have a better understanding after this. So the first appeal issue is that the hearings official erred by imposing condition number 15, which is prohibiting the development of any residential above 900 feet in elevation. And this condition that was imposed by the hearings official in effect precluded developing on lot number 36, and I'm going to give you a close-up of it here. This is at the extreme southeast end of the property, and its access would have actually come off of another road, and I think it's the other portion of Randy Lane that's over in this area, and it would have been a driveway connection with its own separate driveway connection. And this is lot 36 right here that I'm outlining. And the 900-foot elevation topo is right here, which almost mimics the property line that was chosen right through there. And so everything going this way is going uphill significantly. When you get up to this area, it's about 930 feet in elevation above sea level. And so the applicant claims that this condition shouldn't be imposed because the property is not part of the South Hills study. And what's significant about that is in our criteria, it talks about no development on lots above 900 feet that were not in existence prior to, I think it's August 1st, 2001. And the hearings official and staff believe that the property is within the boundaries of the South Hill study. And the applicant has an argument about that, and I'm not going to try to get into the applicant's argument. We're going to have time for that from the applicant. Staff agrees, and also the city attorney's office gave us a memo on that, and that was part of your attachment E to the agenda item summary, and that explains what our rationale is for believing this property is in the South Hill study. Staff agrees with the hearings official's decision and the proposed, or the conditional approval, and we disagree with the applicant in the proposed revised condition that the applicant is offering that would allow future development and structures other than a dwelling. We think that would be a violation of our code criteria under residential lot standards. And I think that pretty much explains our position on appeal issue number 1. Appeal issue number 2 is that the hearings official erred in applying the 40% common open space requirements that are in Eugene Code 98325-12C. And during the process, when we were going through the hearings official process, staff actually recommended denial based on this issue, in that we disagreed with what the applicant was showing as common open space. However, the hearings official decided to create a condition to try to deal with the issues that we had with the common open space, and staff now concurs with the hearings official proposed condition number 16 that deals with how to treat these private areas, as I'm going to show you here. And hopefully that shows up pretty well. Yes, it does. And you can see the hatched areas on the lots. That is the proposed common open space. The argument we had with that is that there are individual areas on individual lots that don't make them common or open if things like fences can go down the property lines and cut them off. And you can see here, this is common open space. This is the required buffer that I referred to earlier coming down through here. And then these were proposed as common open spaces. Some lots had significant ones, some lots had very small ones. And then through here is the Goal 5 protected area where it's a little creek that comes through and empties down into Vedera Park. And then significant area down here wrapping around that borderline with lot 36. The applicant is arguing that this standard only applies to land, again, within the South Hill study, and also asserts that through Oregon revised statute under the needed housing statute that it prohibits the city from applying this type of standard because it's too ambiguous. The hearings official proposed a condition that would require deed restrictions to keep all of those areas free of buildings, structures, streets, fences, and other improvements. And as I said, here, staff concurs with the hearings official decision to create that condition. Move on to appeal issue number 3. And this one gets pretty complicated. The overarching appeal is that the hearings official erred in applying the 20% slope grading limitation. And within this argument, there are 5 sub-arguments that the applicant is making. I'm going to try to walk through all of these real quick. The first one is that the hearings official erred in finding that the applicant did not carry its burden of proof in proving that Lot 29 can be developed without grading on it. And the next issue is very closely tied to this one, so we'll just talk about them both. Sub-issue number 2 is that the hearings official erred in conditioning the combination of lots 28 and 29 to take care of the problem with trying to grade on slopes greater than 20%. And I'm going to show you a close-up. And here we have lot 28, which is right here. And this is the extension of Randy Lane right through here. And then this lot back here is lot 29, which does not have any frontage on Randy Lane. So its access is through an easement that would, I've outlined here in red, that would come up between lots 26 and 28 and provide an access to lot 29. And as you can see, you've got a yellow area here, which are slopes greater than 20%. The building area is this white area. And so you would have to get a driveway from this point to somewhere in this point to get access to your house if you built one, and you would be going above 20% and grading on an area to put in a driveway. And I think right here I want to get into a little bit about the definition of grading versus excavation so that we're all clear. The Land Use Board of Appeals, or I'm going to refer to as LUBA, and most people know it as LUBA, recently considered the distinction between grading and excavation in a case that we had, Fairmont Neighbors Association versus City of Eugene. This was back in November of 2018, very recent decision. LUBA affirmed that the Planning Commission, that their determination that excavation is an activity that is distinct from grading, and that it articulated the definition of grade as to reduce to an even grade, whether on the level or in a progressive ascent or descent. In contrast, LUBA articulated that the definition of excavate as to hollow out, form a cavity, or make a hole, or put a hole in. The applicant in the Fairmont Neighborhood Association proposed a development configuration that required the excavation of holes to install support posts for cantilever dwellings, and the excavation and refilling of trenches to install water lines in areas of steep slopes. In contrast, the applicant here proposes traditional grading activities such as driveway construction and the leveling of areas for pads for foundations. The applicant here, in our opinion, didn't provide staff with sufficient information to show that these traditional grading activities can be accomplished without grading or with excavation. I'm going to go on to the next one. The third sub-issue was that the hearings official erred in not finding that a house and a driveway could be reached by excavation on lot 36. And again, a close-up of lot 36 shows that you've got areas of 20% slope all through here. The building area would have been right in here. However, the distinction in, actually, I'm going to jump, put this out. Okay, so I want to make it clear here that so the hearings official found there was no need to rule on that specific issue of whether you could build and put a driveway on lot 36 because she found that the lot was over 900 feet in elevation and therefore, and it did not exist as a separate lot in August 1 of 2001, which is one of our code criteria. And therefore, she felt there was no reason to rule on whether or not you could get on it since you can't develop it anyway. And the applicant is claiming that she should have ruled on whether a driveway and a house could be built on this lot. Sub-issue number 4 deals with lots 2 and 3, and that she failed in finding that these could be reached by what they want to refer to as excavated driveways. This is Hawkins Lane on the left side of lots 2 and 3 here. And you can see this green sliver of area here, which is 20% or greater slope. The applicant has made an argument that this area of land was man-made, leftover remnants from when the road was constructed. In our opinion, that's not really the basis of the argument. The argument is whether the ground is over 20% or not at the time that they've come in to propose building. And so we're looking at this area of land as definitely over 20%, and therefore you can't grade a driveway through it. The hearings official proposed or came up with a condition of approval that provided for an easement from Lot 1, which doesn't have that limitation, that would then potentially provide access to Lots 2 and 3 in some configuration. And sub-issue number 5 is that the hearings official failed to consider that the applicant's evidence that houses and driveways can be developed by excavation alone and not through grading. To talk about that, the hearings official determined that the applicant's evidence did not depict the proposed site or development on slopes that were exceeding 20%. The evidence that the applicant gave appeared to be on flat terrain. And so the hearings official proposed conditions numbers 1, 2, and 3 to ensure that grading does not occur on any slopes that are 20% or greater. Regarding condition number 3, I'm going to skip ahead here. That condition, as you can see up on the screen, is up, well, it's up on the screen. I'm not going to read it for everybody, but staff is recommending that this condition be changed a little bit to both preserve the intent of what the hearings official had and also to provide for consistency with the requirements of the Eugene Code, specifically EC 9.83255. And so we're proposing to change that to the final site plan shall include a statement that no grading will occur on any slopes, that the tentative site plan depicts contains equal to or greater than 20%. And then appeal issue number 4 is that the applicant is requesting a condition of approval to allow the combining of lots at final plat to reduce wetlands impact. And the hearings official found that this proposal would avoid the review of site plan and would modify the PUD without compliance of residential lot standards. Staff's opinion is that it would also allow the applicant to circumvent the entire PUD review process, and so we support the hearings official decision. We think what the applicant is proposing is to be able to come back and to deal with some of the, you can see a number of areas that are wetlands on here. Some of them are protected, others are not protected, but they're still wetlands. And the proposal would be after tentative approval of a PUD that they could come in during the final PUD phase and then rearrange lots, combine lots, so you would have maybe less lots, which is in direct opposition to what the code criteria says, that basically your final PUD has to be in substantial conformance with the approved tentative PUD. And I think I've covered it all at that level. So I'll leave my presentation there. Thank you.
Okay, Lauren Summers, do you have any follow-up comments?
Thank you, Chair Taylor. Before you open the public hearing, I just wanted to say as a reminder, both to the Planning Commission and for the benefit of those who might be participating tonight, to talk a bit about some of the procedural issues and restrictions on the Planning Commission in this appeal process. I may repeat a couple of the things that you have already said, Chair Taylor, so please bear with me. At the end of the day, ultimately, what the Planning Commission is tasked with doing in this appeal is to look at the appeal issues identified by the applicant, to look at the hearings official's decision, to look at the evidence that was placed before the hearings official, and to determine ultimately whether the hearings official got it right. If the Planning Commission agrees with the hearings official, you can affirm her decision. If the Planning Commission disagrees with the hearings official, you could either modify or reverse her decision. In the course of this appeal, you are restricted in the things that you can consider. You can only consider evidence that was available to the hearings official. So in other words, Planning Commission cannot consider any new evidence that the hearings official didn't see. So for folks who are speaking or submitting written testimony tonight, you're free to argue that the hearings official made a mistake or that she got it right. And you can refer to any information that was presented to the hearings official to make that argument. However, you may not present new evidence to the Planning Commission. For example, new photographs, plans, other materials that the hearings official did not see. If you begin to talk about new evidence, the chair may stop you and/or at some point the Planning Commission may need to affirmatively reject that new evidence. In addition, the Planning Commission is restricted in that they can only consider the appeal issues that were raised by the applicant. So there are large portions of the hearings official's decision that the applicant did not appeal, and those are not open for discussion. The Planning Commission doesn't get to make changes to those pieces of the decision. And I would just say that to help staff in the Planning Commission, to the extent that folks testifying tonight can point to the particular appeal issue that you're talking about, and/or the code approval criterion that you think the hearings official incorrectly applied, that's very helpful to the Planning Commission. And that's it for me.
Okay, great. So before we open the public hearing, I want to go over a few procedural items in addition to what I've already talked about and as well as what Lauren Summers has gone over. As previously mentioned, we have until July 6th to reach a decision on this appeal. We will not deliberate tonight or take action. The follow-up meetings that are scheduled for deliberations are June 24th and June 25th. Once again, you are welcome to attend, but at that point, there won't be additional testimony. So at this point, perfect, thank you. So we don't have a lot of people here testifying, so we're gonna loosely watch the clock for like 3 to 5 minutes just to make sure everybody can go home at a decent hour. But not everybody, not the applicant for introduction. So I'm going to first start. So the applicant is going to take more time in the introduction and the rebuttal at the end. But it's just in terms of public testimony. And we are going to be flexible, but just keep in mind that be respectful so that we go home at a decent hour. But we don't have many. And I want to make sure we give everybody a chance to speak. So once again, if you have arrived late and you want to speak and you haven't filled out a green form, please come to staff's desk, grab a green form, or actually in the back, grab a green form. And then once you fill it out, just bring it up to staff. So now I get to gavel again. I'd like to open the public hearing of the Eugene Planning Commission. If I already went through this, if you'd like to speak, obviously I just talked about that. Please fill out the request, the to speak form, and bring it forward to staff. When you come up to speak, please state your name and address before beginning your testimony. So we're going to first start with the applicant and those in support of the application. So welcome, applicant.
Not going to cry. Bill Close for the applicant, and Carol Schirmer is here. She's going to sit down at the machine and borrow Nick's little magic mark red pointer clicker thing. Two reasons for that. One is I've never done a PowerPoint presentation in my whole life, and I'm Social Security already. And I don't want to start now. And the other reason is she designed the project, and she really knows these graphics. And I'm going to encourage her to speak intelligently at the right times. Okay, so staff, in addition to this exciting PowerPoint presentation, staff have some handouts for you. Have you gotten them already? Have. Okay. These are the two reasons we're handing out these hard copies. One is these are the two most important documents, touchstones for my testimony tonight. And the other reason is I am assuming that your eyes are kind of like my eyes, and that's only going to be, 50% of the game. The fold-out item is the principal sheet site plan for the whole project. And the 8.5 by 11 3-pager is the testimony that was prepared by our landscape architect, also our PowerPoint facilitator, responding to the dust-up over in the hearing record building, responding to the dust-up over the difference between grading and excavation, and whether driveways in our lives are graded or excavated, and whether house sites are graded or excavated. And we'll get to that later, but here is an expert that says they're all graded, they're all excavated, they're not graded. And there's a narrative that describes in detail how that's done, and there's some color graphics there that show it in progress. And this is the testimony which staff has heartburn over. Staff thinks that all this is really done by grading and not by excavation. And that's a critical distinction for our entire application. So actually I'm going to see you more this summer. As I look at my calendar, I think I'm going to be here over the summer with probably 3 appeals. Every one of them is going to be intrinsically exciting. Land use law in Eugene does not get any more exciting than this. There's so much material here. I have decided to settle on the staff report, which is plain English and nicely organized, and use that as an outline for my remarks. But remember, attached to this is hearings official decision, my actual appeal document, which was originally going to be pretty perfunctory because I thought we were just going to was going to do a very short appeal statement that just did a bullet point listing of issues and figure we can really argue these points at LUBA. And then when I was done, I had 17 pages. So 17 single-space pages, and I apologize for that, but it's all there with a couple of the key graphics attached to the back. So if I could just start with issue number 1. Oh, I'm not going to start with issue number 1. I'm going to start with Carol Schirmer, who's going to provide us with a color glossy overview of the project. And there, hard to read, is the site plan, which you have in hard copy in front of you in your fold out. And that shows everything. The roads are going to be private. You can see those. The yellow is
these private roads. Right?
Yeah. The areas shaded yellow are what the topographic map shows to be 20% or greater. So those are hands-off in terms of grading, but they're okay for excavation. And then the light green line around the edge is the 30-foot landscape buffer that's required for any project for whom the owners dare to take the project through the clear and objective standards track. Carol, is there anything else on there exciting? Lot lines for 36 lots. You see in the east corner, you see lot 36, which Nick showed you during the staff report, which is everything above 900 feet. So let's see what Carol has on the next slide.
The next slide was just, oops. Okay, Nick, what's the trick for making?
Just click on that.
There, did I make it let go? Oh, there we go. So I got it, I think. No? Where's my, there it is. Jeez.
Aha.
Yeah, thanks.
Aha. This is the old project. The property owner, go ahead, Carol.
Well, you know, I don't have a lot of detail about it, but this is the project when it came into our office and it was approved as designed with quite a bit of site disturbance, and it was clearly under the general criteria. There's no 20% slopes or 30-foot setback or 40% open space. It was just sort of clustered around Randy Lane. Randy Lane would go through, and then there was quite a few roads that went in to create these small lots, and we thought perhaps we could provide some more generous lots and less pavement going through the project. So that's about where we started from.
And the owner had a final PUD approval to develop that, and over a period of about 10 years, he couldn't find anybody interested in even touching it from the standpoint of actually doing the development. It was a dog. And so Carol started from scratch with a brand-new site plan, and here we are. And what's this slide, Carol?
Well, we were talking about wetlands at this point. We had a wetland specialist, Brian Meyering from Wetlands and Wildlife, go out and do a pretty recent delineation. It's not a concurrence through the state, but he went out and delineated where the wetlands were, so we had a good place to start about what we were dealing with, where the water is on the site, and how much of the site's encumbered by wetlands. And then right here is where there's wetlands in the, it doesn't have the creek that flows into Vedera Creek. So this is the Goal 5 resource here.
That's the South Hills Goal 5 Creek. And it comes off the property to the north, and it disappears into a pipe on the west. And it has a 40-foot protected area adjacent to it.
Okay, and then
And we do have a wetland concurrence on that wetland delineation. And so what do we have there, Carol?
Well, this is where we started. We presented this at to the hearings officer. We just sort of started building the site. Instead of showing a site plan, we started taking it apart piece by piece to show each one of the clear and objective standards that are imposed on a site that applies under this the needed housing application. So we just thought it would just provide some clarity about how challenging it is to design and develop a site that has clear and objective standards that are theoretically to facilitate housing and density and infill. So we just put the site plan together piece by piece so everybody can understand the pieces as it's laid over. Sometimes in composite it's hard to see the impacts. And so this is the 30-foot buffer as it runs around the site. And this little piece right here, because there's a road that attaches right here, that dead ends right here, you don't put a 30-foot buffer.
Randy Lane stub.
Yeah, the other end of Randy Lane. After that, we added common open space. So that was the 40% open space, which also includes the 30-foot buffer. So that's how much of the site was required for removing 40% of it from any development.
And what have we added?
Apparently, my staff got creative with colors, and we have the magenta, 20% slopes that are all over the site. Some are more in aggregate, some are little pieces and parts that are scattered throughout. It's the Goal 5 resource, and it has about a 40-foot setback on each side. It's a very skinny resource, so it's about 80 feet wide, probably a little more, but that.
When you do development in the South Hills and you go check the Goal 5 maps, you see worms, because they don't know exactly where that stuff is in the South Hills. And so one of the things you have to do in connection with your proposal is go locate precisely where that resource is and then indicate your 40-foot setback, so that's exact now.
Oh, and this is the other piece of the 40% slopes. This is a different color. These are the ones that we're calling artificial 20% slopes, because those were created in the course of Hawkins Lane being installed. So those are also a challenge on the site. We thought artificial 20% slopes shouldn't count, but apparently they do. There's no distinction between them, so we just identified them.
And we actually haven't raised an issue about artificial slopes should be okay to grade in this appeal. We did with the hearings official and we lost. We haven't carried that issue forward.
And then we overlaid the wetlands over it. Now, wetlands are we're able to develop on top of those wetlands, but we also wanted to see the impacts of the site. So pretty much what's left over for development, if you steered clear of everything, are the white areas. And then we added the roads and the lots, just so you could see where we finally landed with the whole site.
Okay, so that takes me to our first issue, which is the prohibition on development of Lot 36, which was imposed by the hearings official. A good place to start. There are really two parts to this issue. On the top of page 3 of the staff report, our issue is stated, and then this issue comes out of the standard in the code at 8325 sub 12A, which says, for any PUD located within or partially within the boundaries of the South Hills study, the following additional approval criteria shall apply. No development on land above an elevation of 900 feet, except one dwelling for a lot that existed in 2001. Hearing official said this lot didn't exist in 2001, and there were other houses on the larger piece of property. In 2001, there were other houses on the larger piece of property from which this is a piece, and those houses are above 900 feet. So you got your 900-foot house. So this one, she said, had to have no development. And the condition 15 is at the bottom of page 3. It says the final site plan shall include a statement that no development may occur on any land above the 900-foot elevation. That's lot 36. So the introductory language of this standard says, for any PUD located within or partially within the boundaries of the South Hills study, which gets us to our, what is the footprint of the South Hills study? And we all know when you look at the South Hills study, you look at the maps, it goes forever. It goes over the South Hills ridgeline. It's big, from 1974, very expansive planning. But in our view, this standard means that this standard applies to anything to which the South Hills study as a refinement plan has been applied by the city. And which then says, so what are the boundaries of the land to which the South Hills study has been formally applied by the city? Now, you've seen this issue before. This came up in the Capitol Hill matter, and city attorney said you should agree with the hearings official, and you did, and that issue got taken to LUBA. LUBA was able to sidestep the issue. They found a way of affirming the approval in another manner. Here, this issue will have to be decided by the LUBA, and so I just want to put that issue out in front of you again and state it in the simplest of terms. When the city should be able, the hearings official said, the South Hills study attached to this property at the time it was annexed to the city of Eugene, which was 1998. And so our response was, where do you go to find that? Who says that? Connect the dots for us. No one's been able to connect the dots. That theory came from the city attorney in the Capitol Hill proceeding. It was adopted by the hearings official without explanation at Capitol Hill. It's been restated here. And what we've done, we've carried forward into this record our chronology of who was in charge of applying planning and zoning to this property from 1974, when this plan was adopted, until now, including when the property was annexed in 1998. And what that chronology shows, it's laid out in our appeal statement in detail, and it's laid out in greater detail in our record materials. What that chronology shows is that no governing body, plans are imposed on property by governing bodies. And what we showed is that no governing body with planning authority over this property at the time affirmatively said the South Hills study applies to this property. So the South Hills study is almost older than I am, 1973, 1974. And at the time it was adopted by the city council. And at that time, the city only had authority to do planning and zoning for the city limits. That's it. Outside the city limits, it was all county. No urban growth boundaries. No agreement between the county and the city as to who had jurisdiction outside the city limits. And so, although the 1974 South Hills study has a map that shows the South Hills plan extending over the ridgeline towards Crestwell, it might as well have been to Portland. The point is, it was only effective inside the city limits as it existed in 1974. Now, at that time, the city could have gone to the county and said, hey, kids, we just adopted this South Hills study. How about you adopt it for the area outside the city limits? The city has done that repeatedly, different occasions for different plans. They didn't do it for this plan. So then time moves forward, and we get to 1980, 1982. We have an urban growth boundary. City adopts an urban growth boundary. The county was still in charge of the land outside the city limits, inside the urban growth boundary, which would have been this. And in 1987, the county and the city reached a peace agreement, and they entered a contract, and the county gave the city planning authority over everything inside the urban growth boundary, this property. But after 1987, the city never made a decision to extend the effective footprint of the South Hills study to anything, to this property. And that's what we document, which we've documented in detail to the hearings official. And so the question was, how did the South Hills study get stuck on this property? And the best theory, there are several theories. The best theory that got put forward was by the city attorney. It stuck at the time of annexation, to which we say, fine. So we go get the annexation documents, and we put all those in the record. They're silent about planning and zoning. Not a word. And then we look at the statutes. And the statutes say, 215.130 sub 2, the statutes say when property is annexed to a city, the planning and zoning stays in effect until the city affirmatively changes it. Well, they didn't do that at the time of the annexation. So when did it happen? And our position is it hasn't happened. So when you ask the question, is this property subject to the South Hills study, the answer is no, because no governing body that had planning authority over the property ever extended it to this property. Now, there are properties, of course, that have had the, I mean, it has been extended in other situations, but not for this property. And that's the big picture. That's much too long of a explanation over this issue, but this, you can understand why it's a critical issue. If we're right about this and the city can't connect the dots, just saying that it happened at the time of annexation doesn't make it happen. You know, it's kind of like the city saying, well, Commissioner Borowski, you want to build an accessory dwelling unit in your backyard, but there's a refinement plan that says you can't do that. And you say, well, does that refinement plan stick to me? And the city says, yes, it does. Well, how do I know that? Well, it stuck to you at the time of annexation. And you go get the annexation order, and you read it, and it doesn't say that. That's the situation we're in here. That's our simple answer to issue number one. So let me shift gears and assume that for the moment that the hearing official is right, and this provision does apply to us. We don't like the condition she stuck on us, because that condition can be read to forever preclude this property from being developed with a house. The final site plan shall include a statement that no development may occur on any land above the 900-foot elevation. Well, that's overreaching. We think that that condition should say, this approval does not authorize any housing on the property over a 900-foot elevation. What if the city changes the standards in the future? The city changes the standards in the future, which would otherwise allow some housing on this site. We should be able to come back in and get the benefit of those new standards. But under this language, we can't do that. So we've included some language that is more limiting. And I would just point out as an aside, the draft amendments to the standards for the clear and objective standards in the code, which you folks have seen, the draft amendments would allow housing at 2.5 units per acre on this piece of ground right here, lot 36. Now, is that going to be adopted by the city? Who knows? You know, that's in the future. But that's the kind of change that can happen. And if that change happens, we don't want the city to go back to this language and this condition and say, you are forever precluded from having any housing on this property. It's open space forever. So that's more than I intended to say about issue number 1. We need that language on condition number 15 tuned up a bit. Issue number 2 is even more exciting. That's the 40% common open space requirement in the code. What the staff has not quoted here is the actual code definition of common open space, which appears on page 5 of our appeal statement. Common open space, an area for the use or enjoyment, I put that in italics, an area for the use or enjoyment of all residents of a development site, including parking area, excluding parking areas, streets, other areas designed for blah, 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 and so on. So it's use or enjoyment. So we looked at that and we said, we're going to design our common open space for enjoyment, not use. And so our proposal was to covenant the 40% to be kept free from any development, structures, fences, whatever, so that everybody could enjoy that as a visual resource. That didn't go well on initial submission to the city. Staff said, oh no, that's not what that means. Staff and the city attorney actually said, use or enjoyment is from the perspective of the residents, not the developer. So you put yourself in the shoes of the resident and you say, I have a right to use or enjoy the 40% open space, which means I get to choose to either use it or enjoy it on a day-to-day basis. I can choose to go set up my barbecue on the percentage of the open space that's in somebody else's lot. That's use. Or I can drive down the street and look out there and see no structures and fences. That's enjoyment. And so the staff said, the city said, it's use and enjoyment. Use or enjoyment means use and enjoyment. Now that's a plausible interpretation of the language. We concede that, which gets us to our conclusion, which we pitched to the hearings official, is if you can read that test phrase, use or enjoyment, in 2 different ways, which means different things, it's not clear and objective. So you can't apply it at all. So let us out from this standard, because by statute you can only apply standards that are clear and objective on their face. And here we have 2 plausible interpretations. And what the hearings official did was say, oh no, that's sufficiently clear. We're going to give you your original proposal. It's enough that your 40% open space is for the visual enjoyment of all the residents of the project. Good enough, let's move on, she said. And she fundamentally failed to address a Eugene case that's exactly on point. And that was the case of Walter versus City of Eugene, which was the Chimoti Trails 5-acre, 10-lot PUD in the southeast hills. And all this is in the record because we put all this in. But there, the city applied a standard that related to dispersal of traffic from the project. And they didn't, it was the 19-lot rule. 19-lot rule requires dispersal of traffic on more than one local road. And the road that we were on there, if you turn left, you could go to the North Pole, and if you turned right, you went 1,000 feet and you hit a barrier. The road continued, but it wasn't developed as a barrier. The city said, you know, this means 2 ways in and out. And we said, no, it doesn't. It just means you need to be able to turn left or right. And so the city denied the project. And on appeal, LUBA reversed the denial because they said that standard, dispersal of traffic, had 2 different meanings. It was sufficiently ambiguous it couldn't be applied. And then they awarded us attorney's fees, which was great. So in our view, we briefed this in our appeal, the Walter case, because we think it's right on point. The phrase dispersed traffic is no more ambiguous than the phrase use or enjoyment. And so we're pretty confident that on appeal, LUBA is going to say use or enjoyment is sufficiently ambiguous that you can't apply it at all. And that is the gist of our second assignment of error, our second issue. Which gets us to issue 3, which, as Nick said, is kind of complex, and I'm going to simplify it, I hope. I'm going to refer you to, it has to do with the grading of 20% slopes. Do we have a graphic to go with this? Yes, we do. Okay, so Carol's put up the 3-page graphic on one page there. I can't read it, but you have it in your hand. And what we said was, there are some portions of this site where we've kept the roads and utilities and stuff off the 20% slopes, but there are some places on these lots where we are going to have to construct driveways and houses on slopes that are 20% or steeper. And so we have said we will do that work by excavation, not by grading. Now we know from your previous decision in the Furtick Family Trust case on 30th Avenue, a little tiny PUD, that there is a difference between grading and excavation. They have to mean different things because they're each a part of the definition of development in your code. And the definitions were adopted there were dictionary definitions. They're just fine definitions. There are a million definitions, but those ones are okay. And excavation is hollowing out, and grading is reducing to an even plane. And that distinction was upheld by Luba on appeal in the Furtick Family Trust. That case was a winner for the city. So we have started with that, with those definitions, and we have said we will create driveways and house sites with excavation. Think excavators, think backhoes, don't think graders. And that became an issue, a big issue before the hearings official. And so Carol Shermer generated this 3-page memo where she states in unequivocal terms that driveways and house sites are done by excavation, not by grading. And she has in there detailed methodology for how each one's done. And you can read them yourself. I'm not going to read them myself because I'm kind of droning on here. And then that narrative is accompanied by pictures. There's a picture of a driveway excavated, and there is several pictures of foundations that have been excavated. Staff really came down on this memo hard in the post-hearing briefing. They looked at that first picture there, the excavated area for driveway, and they said a couple things. Well, that property is not 20% or steeper slope. Well, it is actually. That's why it's in here. 20% slope is 5 over 1. 1 over 5? What's the right phrasing?
Either way.
Either way, good. 20% slope is not as steep as it used to be. It's really pretty shallow. And secondly, staff said, we think that driveway was graded before it was excavated. I mean, we don't really know how to respond to this. He's really challenging the evidence from our expert witness, but he's not really explaining what's wrong with it. I mean, here we have a narrative that's been unchallenged, and we have graphics that are illustrating the narrative, which have been challenged but haven't really been explained why they're wrong. So we believe that this evidence, which is uncontroverted with a sort of a logical explanation, supports our proposal to excavate driveways and house sites where we need to, on slopes that are steeper than 20%. So that is our major evidentiary pitch. Now we have a couple graphics here that resolve the, I mean, Nick said there were 5 sub-issues, and there are, but I think I can bundle them a little bit. So one deals with the relationship between lots 26, 27, and 29. In order to get to lot 29, there's a smidgen of driveway that has to be excavated across 20% slopes. We can do that by excavation. The hearings official says, well, I'm not sure you can do that. We're going to require you to merge lots 28 and 29 into one lot. So you don't have to do that excavation. She says, grading. We're going to excavate. She says, you have to merge those 2 lots. We believe that if we have convinced you that that work can be done by excavation, then there's no need to have the condition that joins lots 28 and 29 into a single lot. That's one of the sub-issues. What's next, Carol? Aha. This is the alternate site plan for dealing with those pesky artificial slopes on Hawkins Lane. Again, to recap, the green vertical line there with the sharp edges are the side slopes that were created in the construction of Hawkins Lane, probably before I was born, and they're 20% or steeper. Now, our proposal is to put driveways on there and grade the driveways, just like we're going to grade the driveways for everything else. Hearings official is making us do an alternate access to come in on lot 1 and then put another driveway down to lot 2 and 3 so that all of that work can be done without touching the 20% slopes. If we're right, the driveways can be excavated instead of graded, then we don't need to have that condition, and each of those lots can have their own sensible driveway coming off Hawkins Lane, because it's okay to excavate slopes that are greater than 20%, whether they're artificial slopes or whether they're natural slopes. So that's that issue. And then there's the matter of lot 36, which the hearings official says you can't put a house on it. Well, ultimately, we think we're going to prevail on the no house on it. We think we're going to be able to put a house on it because of the Southfield study issue. You can see how you can come into lot 36 off the Randy Lane stub, follow the under 20% area. That's good, Carol. And then get over there to somewhere on the west end of the lot, pick your area, and excavate a house foundation. Empirically, there's plenty of room to put a driveway and a house on lot 36 and only excavate for house construction and driveway construction. So that issue should really be resolved in our favor. And I think that's the glossy summary of issue 3. And so this is up there because, this is issue 4. I struggled with whether or not to raise this issue at the end of our appeal. But all that blue stuff's wetlands. They're just everywhere. And it may be that we would want to combine some lots. I'm not talking about reshape them. I'm just talking about taking out the common line between 2 of them, having one less lot, but the same configuration. All the lines would stay the same. We just take out some lots as a way of avoiding some wetland impacts. Fewer houses, less wetland impacts. And to be honest, we were just asking for the discretion to be able to do that on the fly where it made sense. That would mean fewer houses, but all the lines would stay the same except for where we join 2 lots. And that caused too much heartburn for the staff and the hearings official. I think that's really, you can include that in an authorization if you want to. I think it's completely in your discretion. That would be great. I think that, Carol, what have I missed?
No, that's it.
Okay. Questions? It's not time for questions.
Can I ask you a quick question, Bill? So I'm assuming I've got a receive date, but I actually have a April 10th, 2019. This is not new evidence. It was part of the record. Yeah, I just want to clarify that.
Exhibit B to our post-hearing.
Yeah.
To one of our post-hearings.
I had a couple of winks on the side of me, wanted clarification. Yeah.
Okay, good.
Are there any other questions by other planning commissioners? Yeah, Commissioner Borowski.
Thank you. Which lot line were you thinking of removing for the wetlands?
Well, we don't know, honestly. We don't really know. It would probably be in the sort of the north-central part of that where things get pretty dense and pretty wet, and the lots are smaller. The smallest lots are kind of on the west, and the larger lots are on the east, and the west end's wetter. We don't know.
So how would you get around the argument that the city has that would put it outside of the public process?
Well, this is a public process, and I think that you have, this would be really a question for your city attorney, but the question is whether you have discretion to impose a condition that authorizes that kind of changes to the property lines.
Thank you.
Commissioner Baker.
Yes, is there, on the same issue, is there some reason you didn't propose the removal of those property lines now as part of the tentative PUD process? I mean, you have the wetlands all mapped, you have all these other features mapped. Why didn't you propose it as part of the tentative PUD?
Well, candidly, the idea occurred to us at the end of the process.
Okay. Thank you.
Thank you.
So the next group of speakers, those were the speakers, both the applicant and in favor. I have two that are neutral. So Larry Smith is the first. And remember just to state your name and address when you come up. Thanks, Larry.
My name is Larry Smith, and Rick Trommel here will be helping me by flipping through some slides.
Great.
We figured that slides are probably the easiest way to get through this quickly because I can spend fewer words. So I'm pleased to be here today. We've been involved in this issue for several months, and I know that, first of all, I have to say that I appreciate how difficult your decisions are, but having been involved in land use planning in Alaska where there's tundra and frozen glaciers and so forth involved, you got it easy. So it's, I've been involved in Alaska for many years with the land use development, and it's a real can of worms up there in many cases. So first of all, we're going to be speaking opposed to the proposal to change the conditions, but I find myself torn because we're in favor of a development that's done correctly. So we're not here to say, kill the development, you know what, throw out every reason to kill it. We've been trying to contain our concerns to things which are really concerns that affect the neighborhood, and that are workable, that have workable solutions. So let me introduce myself first. I'm the president of the Vedera Drive Homeowners Association, and go ahead and click next slide. Okay, and I am a homeowner in that development. We're directly adjacent to or downstream from this development, just right across Hawkins. And we have the distinction, we're directly affected by traffic in any of the issues regarding that, and the public amenities up there, including the common area. And the comment that the common area is only for the use and enjoyment of the residents, I believe, is misconstrued. I think common area is for the involvement of the whole public, and that's part of the intent behind Eugene Code. But we have the distinction of receiving 100% of the stormwater drainage from that site. And it turns out that it comes across our development through a private conduit. We have a culvert across our road, which is privately owned, and by the way, has no easement, which is another issue we won't bring up here. But all of the drainage from that whole basin up above us comes down through our property. And the reason that we're here, and one of the big reasons, is that reaches peak flows that erode banks, and with the rainfalls we've been having, it is a mess, and we can't afford any increase. And so we're here to make sure that the development up there complies with the code, and that we don't see the devastating effects of increased flows, especially through the climate change we're seeing. And the issue of ownership and of the right-of-way through there, we'll leave that alone. That's other business. I'm the president of the HOA. There's 81 homeowners, and I've gotten their approval to represent them in the issues here tonight. And I do have a background, technical background, to understand the issues and try to present them. I say that if I get carried away, please stop me and ask for an explanation if I go into some terms that are a little bit too technical. I'll try not to do that, but go ahead, Rick. So the position on the issues. We fully agree with the conditions stated by the hearings official in the decision, and we do oppose all of the appeal items, although we'll only speak to 3 of those. We will not speak to issue number 1 regarding the lot at the top end, lot 36. We're not giving testimony on that. We will testify to the other issues, and this little thing at the tail end here, I'll ask your indulgence, and if you think I'm overstepping when we get to it, you'll see that it's some recommendations rather than for you to take as you will. And they don't really address specifically the appeal, but I'll get to that, and you'll see that they're in context.
And,
right.
And have they already been presented? I guess that would be my question.
They haven't, but make this a separate aside for you guys to look at. It's simply saying, pointing out areas that maybe you should consider for future. But I can tear that out of the.
Yeah, I think that's probably advisable.
All right, I'll do that. We'll bypass that.
Perfect.
Okay, but let me say that everything I'm going to be talking about here is contained within the record that's already been submitted. Great. And I know there's thousands of pages, and for your convenience, I wanted to pull out the section that's really the reference material that supports, because I know it's difficult to find that. Can we approach and give you this?
Yes, staff, can you go ahead and give it to staff first?
That's what I already gave them, right? Yeah. Oh, that's, okay, never mind. Yeah. No, that I don't have. Okay.
So I'd like you each to have a copy of that, because some of the areas you get into are better understood if you go back to the source material, because I'll make some allusions to that material here, and it's all backed up within that analysis. All right. So first of all, let's talk about the 3 things we will be addressing is the grading restriction and the extent of the slopes with exceeding 20%. And then we'll be talking about the open area and one of the very important conditions that we see in the hearing official's decision that says that HOA will be formed. We find that to be critical. It's not been covered anywhere in the proposal, but the hearings official had the foresight to put that in as a condition, and we think that is critical. And we'll get to why that is. And that pertains to applicant request 2, because that's in condition number 16, where the hearings official makes that requirement. The third thing is the need for further public review. We'll speak in support of that, because there's a number of issues that the hearings official raised as conditions that could not reasonably be answered without enough changes that it will require we come back and look at those changes at some point. And so sometime before the final approval, those really have to be reviewed. And then finally, I'll drop that last one. We won't get into the recommendations. So, all right. So first of all, a great deal has been made of the definition of grading. I hadn't heard before, but in Nick's discussion of the LUBA decision regarding the distinction between excavation and grading, it was clear from what he described there that LUBA found that drilling for pilings is considered excavation and may not come under the definition of grading, because, and it's easy to understand why they would reach that decision when you look at all of the conventional definitions of grading, which really grading is anything that changes the topology of a piece of property in any way. And so I would refer here to the different codes and the definitions within the codes. And this is this is in response to Bill's testimony, and I hope that I'm permitted to cite these. These were not cited in the original, because this is in the form of response to the current issue. So the claiming that the definition of grading is critical, I have to respond to that as a professional witness here. So is that going to be allowed?
Staff, I'm going to actually ask you, Lauren Summers, we do have obviously a definition as what was described in the record, so can you please respond?
So Commissioner Taylor, I think what will need to happen, I think, is that staff will come back to you at deliberations to go through the testimony that's been presented tonight, if it includes what we believe to be new evidence.
Okay.
We'll let you know about that, and then we would ask you to reject that new.
So then it allows Mr. Smith at this point
let
to
me
communicate without stopping should I just let him speak? You'll review it and all the various components.
I don't know the record well enough to know
Right.
exactly what's included.
Okay.
So I think we will need to come back to you
Okay.
with deliberations and ask you to reject.
Okay. So, Mr. Smith, I really appreciate your honesty and transparency. So as you're working through it, if you mention that will help staff, and we don't need to,
Okay.
at this point, the record is large, so go ahead and make your
Okay.
presentation. But
So-
where you can add those nuances, that's helpful.
Very good. Okay, well, what's important here, I think, is the question of what is the standard definition of grading. And it's clear from building codes, as well as other ordinances, as well as LUBA's findings, that there is a distinction between grading and excavation. And the distinction is that grading encompasses excavation as a means of achieving the grade. And so, in other words, there's a hierarchy here. Everything that's graded doesn't need to be excavated, but everything that's excavated is graded. And so the term grading does encompass all, and that's consistent with the International Building Code 2015, which defines excavation and grading as that. Excavation is the removal of earth. Grading is an excavation or fill or combination thereof. So if you're excavating, you are grading as well by that definition. Rick, next. And if you look at other sources, your sister city's code, they've done a good job of defining grading as any means of land disturbance, including excavation or filling of earth materials or any combination thereof. That's their definition. And then other city codes, grading is to bring an existing subsurface or surface to a designated form by excavating, filling, or smoothing operations. So clearly excavation is part of grading. And then finally, our most authoritative source, of course, is Wikipedia, right? So Wikipedia has an engineering definition that says something similar, that anything that achieves a certain grade, a slope, is grading. And so any kind of putting roads, for example, into Lot 36 or across the frontage to Hawkins Lane would be grading by any of these definitions. And so we can't couch an excuse here under semantics where it's not the common usage that's being presented by the applicant. Any questions on that?
You can keep going. I want you to know, though, and the public, that if these weren't brought up before, they wouldn't be able to be considered. So just keep that in mind as you're moving through.
All right, thank you.
Yeah.
Well, then let me just testify that the common sense would say consider grading to be for what it is. All right, next. Okay, our next exception is in terms of the, assuming that the grading is recognized for what it is, there's an error by the hearings official, which I think needs to be corrected on record, and that is, there was a point made that the green areas that were identified by the applicant did not encompass all of the 20% grade areas. And the hearing official found that that was the case, relying on the stamped engineering drawing that showed a topological map that shows it as such. And determined since that plan is based on a topographic map which predates the construction of Randy Lane. And so the topo map is not accurate. Now, the applicant probably used the best information possible, but fact is it's not correct. And now you can see the drawing in the left-hand corner would probably represent more accurately what's there if they upgraded the GIS to show that. And you can see clearly there's areas as shown on the green at the far right, the dark green, that are going to show as greater than 20%. Now, realize that now this is all evidence that was shown in the packet that was submitted before. You can see the cross sections A and B, which are shown here, show up to 56 to 60% grade on the frontage from Lot 18, Lot 15 on the Randy Lane and Hawkins. And Lot 18 specifically, if you look over on the right-hand side, really has no possible access from Hawkins, similar to Lot 15 and 18 have no possible access without grading across steep property. And so Rick, go ahead and you can see the pictures, which are also in that previous packet, that the frontage along Hawkins, you can see visually that it's steep, and you look up Randy Lane and you see it's steep. And again, along Randy Lane, it doesn't show on the topo map as being steep because the topo map that it was based on is at least 20 years old. So it does not include Randy Lane in there at all. And you can see that when sidewalks are added to Hawkins, because that's a requirement, is that sidewalks be added there, it's going to even worsen the situation because that will cut in to that slope at the toe even more. Okay? Now, one very critical one, as I mentioned, is the hearings official had the foresight to require that there be an HOA as part of Condition 16. The applicant here would like you to change the language to not include that requirement. That we feel is very critical because the administration of this entire development in the future for all of the landowners there, we believe would fall into chaos without having some sort of HOA. And that HOA would be there to administer the common lands and enforce the covenants or the conditions of in the title that were required there. But in addition to that, they would allow them to maintain the private roads and the infrastructure, have a way to do that. They would have a way to finance future improvements, enforce the deed restrictions, and also preserve and protect the common open areas in a very rational fashion. And it would become a single entity for resolving disputes with neighboring communities. Now, a dispute that we expect, unless there's some modifications made to the plan that will come up, will be regarding the stormwater. And if this is developed and no changes are made to the plan, we fully expect to be in a contentious situation in the future over stormwater. So let's go to the next slide. And the major defects in the proposed plan, really, most of the ones that we're concerned about, would be alleviated by assigning traditional roles to an HOA as part of that Condition 16. And that would be common open space. If you've got an HOA, why try to keep it with the individual lots? Go ahead and put it as common area that would be administered by the HOA, set the boundaries there, make it clear what's open and what isn't, and cut to the chase. Why the complexity of requiring all these boundaries or putting it on individual property? And combined under the control of the HOA, it could be administered with proven practices because, part of an HOA, we know how that works. Over the last 30 years, our HOAs had many, many issues that have had to be resolved, and I couldn't imagine individual homeowners doing that. Rick, go ahead. And one of the outcomes would be the stormwater management under the auspices of an HOA would allow the capacity issues to really be addressed. And the underlying issue that we have regarding stormwater is, and the wetlands that are shown there are actually collection ponds currently. So if you could look at it and say that property already has significant stormwater treatment. In fact, that stormwater treatment, by using studies that are shown in the report you can see that's already of record, is anywhere from 5 to 13 times as much capacity as what the Eugene Stormwater Management Plan would require to engineer as new capacity. So it's extremely effective, and we would maintain that in order to meet the requirement of not exceeding the current stormwater flows, that effectiveness has to be matched. And there's nothing in this plan that actually matches that kind of capacity. And I believe that if they can open it to an HOA to take some of the common property and turn it into a pond, similar to the pond on Randy Lane, we would have an easy solution to this. And I hope that the developer will consider that.
Mr. Smith, can I remind you that we're here at this hearing with the objectives of what the four
And this is
appeal
addressing
items.
specifically the HOA role and the need for an HOA, which is part of
So
condition
just
16.
Remember to keep the conversation
Okay,
relevant. Thank you.
All right, moving on. This is the one we will, okay, this is addressing the request number 4, which is to not have review of the proposed changes. Condition 3 of the decision requires a detailed plan meeting all the requirements before disturbance to the site. The applicant is requesting permission to revise without review. That should be denied. The decision conditions plus revisions that have already been agreed to by the applicant have never been put into the plan itself. You know, there's been some correspondence that says here's some things we can do or will do. Those have not been reflected in a plan that has been publicly shared. And there's a number of those. Some of those changes that are required include street changes, vehicle access to all the lots, the sidewalks that are required on fronting Hawkins, the rights of way that are required for shared driveways and so forth, and the stormwater provisions, which the HO is also requiring be provided for before the final PUD. And so all of those really need to be reflected in a plan before it's under public review. Okay, next. And we believe that the stormwater memorandum that's required needs to be part of that. It needs to go into the final plat that we see and not just brush it off as kick the can down the road. It's the HO required the plan. We should see that plan before, publicly before approval. Okay? And then these are the recommendations. I'll skip through those. I'd invite you to read those there because there's several things that...
We're going to actually not read those.
Yes,
Yeah,
okay.
thank you.
Thank you very much. Appreciate your time. Let me, oops, go back. Can you?
And I want to make sure the public understands that if there's new information, and Lauren discussed it, I did, if there's new information that hasn't been in the record, we have an obligation to actually not review it. So I appreciate you disclosing that.
Consider that input, if you will.
Yeah.
But here's, in my summary, I'd say that we'll be pleased to welcome new neighbors when the proposed PUD is complete. But we ask that the plans recognize the special nature of this property and conform to the pertinent laws. And the affected watershed, it may not be well known, but this is part of the evidence here, that this area comprises 5.6% of the total wildlife habitat within the whole city limits of Eugene. And all parties, including the applicant, have stated that a large part of that is on wetlands. That's been recognized. The application delineates that. And you can see on the right, the blue area, the extent of those wetlands. And those are not just a wildlife habitat, but they are also water storage and wildlife habitat. And all parties have identified this as a challenging site. And there's good reason that it hasn't been developed up till now. It is a challenging site. You know, the steep slopes, the wetlands are all factors that make it challenging. And then finally, I would say that we would like to have worked this out before this point. We've approached the applicant proposing some small changes which we believe would have mitigated all of our concerns, but we really haven't had a dialogue and haven't had real willingness to engage outside of this forum. And I hope that going forward, we can get some of that conversation going. We believe the city of Eugene has really protected the interests of the entire community in not only in crafting effective laws, but in the staff. The staff is to be congratulated. They've done a great job of reviewing this. Hats off to them. But I ask you to resist any attempts to dilute the intent of the law and to redefine terms such as grading in order to permit a flawed development application. So thank you very much.
Thank you. Planning Commission, any questions? Okay. So we'll move to the next neutral speaker, Robert Napora. Maybe we lost Mr. Napora. Okay. So we'll move to the next group of speakers, to the against or opposed. The first speaker I have is Diane Lewis. Hi.
I thank you for your time.
Can you just...
to the staff. My name is Diane Lewis, as you mentioned.
An address, that'd be great. Thank you.
2310 Shields Avenue. So I am adjacent to the property and have lived in the area about 15 years. Again, I am a neighborhood watch co-captain, and a bit disappointed that there's not more neighborhood watch and associations involved in this process, in particular for this property. The gentleman that spoke prior to me did an amazing job explaining the surge protection and the stormwater runoff that this wetland area provides. It is an amazing area. I think it has potential for development, but to the extent that has been presented in no way meets the intent of the proposal. I find it very frustrating now on my second time here that we continue to discuss whether this is in the South Hills area. And I would question, is Braywood 1 and Braywood 2, were they in the South Hills area of consideration? It seems a slippery slope when sometimes the developer seems to want to apply meanings and definitions to the benefit, and it seems to have flip-flopped since the first presentation to the rebuttals of the decision on the appeals. I find it very frustrating going back and forth over the excavation versus grading. It's very elementary to know that there are very few houses here that are on slabs, which you excavate, which you can grade, which you can backfill and bring to a reasonable slope. Most homes, if not all, I could say, in the South Hills have basements. The only way you can have a crawl space in a basement is to excavate. So I would like to have some confirmation on what are we doing on these slopes. Are we in the Southwest Hill development area? Do we need to keep these percentages above the 900 foot? And where are we? It just seems to be a back and forth, and I appreciate the time that the staff has taken to really delve into this issue. It's a very small parcel of land. You can see we're very dedicated to not only doing the right thing for the land. We welcome neighbors. What we don't welcome is not having a good stormwater plan. We don't welcome not having a good pathways and a area that's been open that seems to have now wanting to be very closed off. Thirdly, we have not really addressed any type of consideration for how these folks are going to be excavating or mass exodus down to the city, down to 11th, down to 18th. Where are we going? How many trips of traffic? Are we going to have any kind of slowing down, speed bumps, roundabouts? In the time that I have lived on Shields Avenue for 15 years, what I now notice is lots of Grubhub and Uber drivers bringing up lots of stuff constantly. And I think that we really need to address our traffic issues. This is great. We welcome folks. It's a beautiful area. Come walk it. My house will be for sale in 5 years. So if you like the area, come see mine. Thank you for your time.
Thank you. The next speaker is Julie Butler.
Hello. as she said, I'm Julie Butler. This is kind of one of those things where, for those of us who live in the neighborhood, the learning curve has been steep. One of the frustrations of all of this has been that the average citizen who finds out that, oh, wow, yeah, this area of land is going to get developed, and you have concerns, the scope of how to address those concerns is extremely limited. And there's not a lot of transparency given to us as to how to go about doing that. And we end up going about it the wrong way. We write letters saying we are concerned about traffic, only to find out that traffic is not an issue because it's not within the code or it doesn't meet a code standard. And so real concerns that we have, we can't address. And we're not told about it until it's too late, which is really hard. So, you know, I'm going to address the codes, and this is what we did, and this is what I've talked to my neighbors about trying to do. I know a lot of them got just really frustrated, and they just gave up. And I think that's very sad in our society that you make it so difficult that people do just give up. And that kind of makes people who, you know, make situations too one-sided. There's not enough give and take. So, when this whole thing started and they had the neighborhood meeting, it's very clear that in our whole neighborhood, there were two concerns, and kind of you've heard them addressed. The water was a concern, stormwater. It's always a concern up in our area. We have underground springs all over the place anyway. And traffic was a concern, and the wildlife was a concern. And we were told that because this went under the needed housing, that our concerns could not be addressed because they didn't, needed housing rules were set, clear criteria, you know, that was that. There was nothing we could do. But looking at the criteria, it came to me that, well, yeah, there's a few things that can be done. One was the whole 40% open space, common open space. And it kind of galls me that so much has been made of this use or enjoyment aspect that Mr. Close keeps bringing up, because part of that definition, the last part of the definition, even states that the common open space can include space that's been set aside to preserve natural resources. Well, that speaks to the whole thing. And you've got to have that in the context of the whole definition. And as we've been talking about with the wetlands, and one of the things that wasn't brought up that I did bring up and others have brought up in prior testimony is that there are old native oak trees in this development too, the ones that are rapidly disappearing from the Willamette Valley, and it has been cited in study after study. Those are perfect examples of natural resources besides the wetlands that are a natural water basin for this. And so it would have been so easy to just utilize a lot of that within the 40% common open space, and you've taken care of the problem right there. I mean, you've done it both ways. But the other thing is that this whole business of use and enjoyment has been, he's kind of overshadowed the fact that the term is common open space. The term is not divided open space. The term is common open space. And, you know, what is the definition of common? Common is not belonging to one person. Common is being shared, or common is, whether you use it as a noun or an adjective, it doesn't matter. It's still, common is public, common is shared, regardless. So I find, you know, I appreciate that the hearing officer said, well, okay, I'll let you have the boundaries, but you've got to, you know, put in the deeds a restriction that says no fences, no da-da-da-da-da. That doesn't make it common, because who wants to walk across someone's private property? It's not common when it belongs to somebody. And I know that originally that was what the staff recommendation had kind of addressed, that it wasn't in 3 contiguous or fewer spaces that the code requires. And meanwhile, they're trying to argue that the code is not clear And therefore, because the code can be interpreted in more than one way, it shouldn't apply to them because it's ambiguous. The code is not ambiguous. I had to learn all this because I was starting from square one. But that code made sense to me from the get-go. I had no questions. It was not ambiguous. It was very obvious. So I feel as though what I'm seeing here is someone trying to say it's ambiguous because I say it's ambiguous, so therefore I don't have to abide by it. And using that as an excuse to do what you want to do, as opposed to what the law is requiring you to do. I really dislike it when somebody's trying to subvert a situation or trying to subvert the codes to get what they want, as opposed to what is required or what is needed. In following that, I want to say that this is part of the needed housing criteria. There was another track. That's the general housing track. And yet a choice was made to go the needed housing tract. Well, if you don't like the rule, you don't want to set aside 40% common open space, then go the general housing tract. It's not in there. You have other methods of doing this. 40% common open space for the use and or enjoyment, whatever you want to say, of everybody would take care of would really appease all the people who are concerned about the wildlife. You know, walking up there and looking at it, there's wildflowers I've never even seen before. I don't even know what they are. I've had to go look them up. I mean, when the camas started blooming, I'd never actually seen camas in full bloom. I had to go look. What was that flower? The wetlands provide a whole lot out there. The hawks that you're seeing, there's fox up there. You know, I'd never even seen a fox before that wasn't in a zoo or something. That would address that. The other issue was, as a neighboring neighboring property, we were all concerned about the traffic. Well, unfortunately, in the codes, there isn't anything that really we could sink our teeth into saying, hey, you're dumping how many more cars on our streets? It's gonna, the way you've got it with your private streets and no connection of Randy, you're dumping literally everybody onto Blacktail. Our neighborhood is Blacktail. It connects and has since it was developed in 2005 and 2006, connects to McLean. It is now physically possible to go from Bailey Hill Road all the way to Lane Community College and never have to go down 18th. And that is what everybody does. And now you want to add all these other cars and literally dump them onto the one street that was never meant to be a thoroughfare like this. It's not wide enough. It's parking on one side only. And you're adding all of that onto it. Well, as a citizen or as a neighbor with the codes given, there was nothing we could address because we were told, nope, we can't connect Randy, we can't help alleviate the situation because there's a 20% slope up there. And yet, now he's arguing the very same argument he used against us on connecting the road to help alleviate the traffic to try to say, oh no, I can make driveways without grading? Are you kidding me? Really? Last time I checked, driveways had to have a certain slopage to keep water from pooling on them and degrading the underneath or keeping them away from the slope of the house. You have to grade a driveway. Or sidewalks. There's gonna be sidewalks up there. They're gonna have to be graded properly. You can't have lumps in the middle of sidewalks or something, you know, to take away the slope. It doesn't make sense. So what I see is somebody who's trying to use a code to get out of doing one thing, but at the same time, subvert it to their own needs or desires. What really concerns me about all this is precedent. Because whatever's decided here, you know that future developers are going to come back and say, oh, but this is the decision that was made. And, you know, if he can get away with dividing out common open space or not having, you know, saying that it's just for staring at from how many feet away, because really you'd only be able to see it if you were in certain parts of the street. I mean, there's no way people are going to be able to view the open space from pretty much anywhere. There's only specific places, and even that was addressed in the original thing. And that's, of course, taking away whatever landscaping that might get up that blocks any of it. You know, what I'm really concerned about is precedent. If he's allowed to get away with these things, they're allowed to say, oh, it's an ambiguous thing. If they're allowed to say, oh, no, you don't have to have, you can divide up common open space, then others are going to come along right behind it and go, oh, wow, let's go that needed housing tract because now it's even gotten more gutted. And now it's really easy to go ahead and build whatever we want to build, and we can get away with just saying, oh, this is ambiguous, or, oh, you know, we can change the definitions of things to suit our needs. So it's twofold. I know you guys are going to have to make a very serious decision, but I also, and I know you know that whatever decision you make is going to be looked at. And I guess that's part of my whole thing, and one of the reasons why I took it upon myself to actually learn what I could say, what I couldn't say, what the codes were. I have to say, Nick has been fantastic. I've had to call him up time and again and say, could you please explain why? Why could the developer, I literally called him up one day and said, could you explain to me why they could not have just shortened all of those really long lots and then just had this nice buffer of common open space at the top? You know, and his answer was, well, they could have. There was nothing that would have prevented it from him. But thank you to Nick for having been so incredibly helpful. And, you know, I can't imagine the job these guys had to do from, my head was spinning. So thank you for listening and good luck.
Can you do me a favor before you leave? Is
Yeah.
just state your address, because we're televised. And
3234 Jayhawk Court.
Okay, great. Does Planning Commission have any questions? Okay, thank you for coming.
Thanks.
I have one last speaker against, and it's Nicholas Limbert, or Liebert? Libert, yeah.
Hi, my name is Nicholas Libert, and I live 2777 West 29th Avenue. All my points were addressed by Julie Butler, so I don't have much to say, except that for me, my house being sitting on top of lot 36, I know how much stormwater I have. And when I take my dogs for a walk on lot 36 and everything, it's amazing the amount of water, even though it doesn't seem to say that there is any wetlands on lot 36. I can tell you that so much water and underground water is going through it. It has to go somewhere, and it has to be grading. So lot 36 being above 900 feet, more than 20% slope, and even if it's not listed as wetland, there is so much water going through it. That's it. Every other point was addressed by Julie. Thank you very much for listening.
Thank you. So I just want to, I appreciate this process. The planning process is challenging. So I appreciate your efforts to understand. And I do want to just let you know, I mean, it sounds like from a lot of the speakers, the key pieces are outside of our review. So I just wanted you to know that in terms of stormwater and traffic and wildlife. So it's outside of our review. So we're really going to be focusing on the appeal items, the 4 items that staff reviewed at the beginning. So I just wanted you to know that. And so are there any staff comments or questions at this point? No.
No more comments.
Okay. Applicants' final rebuttal.
Thank you. 3 points. I always try to work with a shopping list on rebuttal so I don't get lost. First of all, no rush in making this decision. I've told staff that we're happy to extend the 120-day time limit for making a final written decision as long as necessary for the Planning Commission to get into these issues just as deeply as they want to, because they are worth it. A lot of stuff came in today in writing. We all heard the testimony, so we know what's relevant, what's not relevant, but I would like an opportunity, short opportunity to address in writing whether materials that came in today from the opposition are inside or outside the scope of this appeal. And I say that because the scope of what's on the table is really very narrow. My favorite case on this is a case, Luba case called Treadmill Joint Venture versus City of Eugene. You know the guy was a housing developer because the name of the LLC. And that was an appeal by my client, had a PUD approved out off the Northwest Expressway, and he had asked for 10 little items, teensy items of relief in his PUD to make his project fit with one he had just finished next door. Setbacks from property lines, eve questions, you know, really big issues. He asked for 10 little changes to make things fit and work. The hearings official, staff recommended, 6 of them. Hearings official says, I've never seen this site, I gotta go with the staff. So the hearings official approved 6 items of relief and said no to the other 4. And so we brought those 4 items to the Planning Commission on appeal. And the Planning Commission affirmed our appeal and granted the relief we had requested on all 4 items that the hearings official had denied. And then the Planning Commission imposed a couple of new conditions of its own, addressing issues that it had come up with as it addressed our 4 issues on appeal. Well, that was not okay. So we went to Luba and we said, look, what happened here is, I used my favorite metaphor at Luba was, I said, we went to the Planning Commission with a broken windshield. And we pulled into the Planning Commission shop and the Planning Commission fixed our windshield, and as we were driving out of the shop, they broke our window. And Luba said, that's right, they did. And that's beyond the scope of what the Planning Commission can do on appeal. So they took care of us at Luba. The point is that when you actually look at the language in the city code about the scope of what you can look at, the city attorney said it's okay for the Planning Commission to get into these other issues. Once an issue like grading is on the table, it's okay for the Planning Commission to address anything about grading. Or once an issue about property line setbacks is on the table, the Planning Commission can look at anything having to do with property line setback. No, said Luba. You look at the specific issue that was raised. I made some bad hamburgers on a grill last night and put some bad slices of cheese on top of those hamburgers, and those were very thin sliced pieces of cheese in a plastic package. It's kind of like, if you call the package of bad thin cheese slices, grading, we addressed 2 slices of cheese, and that's it. Once the Planning Commission gets into the package, they can't address the other slices of cheese. That's not a very good metaphor, but it's current. So it's very narrow, and I'd like an opportunity to just look at the written materials submitted and address them from the standpoint of what the rules are established for Planning Commission based on the case law. The third issue is a substantive issue, and that has to do with grading and condition 3. Nick, you proposed a modification of the hearings official's condition 3. Can you find that one and put it back up there for us all to look at? Aha, okay. So the top paragraph is what the hearings official imposed, and the bottom paragraph is what staff is now recommending. It's an improvement, but it's not good enough. The final site plan shall include a statement that no grading will occur on slopes that the tentative plan depicts contain slopes equal to or greater than 20%. Now, what does that mean? What's not okay is if we submit final plans and staff in any fashion look at that and make a judgment call as to whether what we're proposing is grading versus excavation. That's not okay. Now, with the staff's proposed language, I'm curious whether there would be any staff review, any staff discretionary review of what's proposed on the plans and a determination as to whether or not it constitutes grading or excavation. If all that's required is that statement on the plans, and if that statement on the plans is there, and then staff take a hands-off position, then it's okay. But if staff's going to be reviewing the plans to determine whether what we're doing is grading or excavation, then we have the same problem as is developed in our appeal. And this appeal issue is number 3A, and it's on page 13 of our appeal statement. The condition above we're objecting to because we say it's not clear and objective if it delegates to staff a subsequent determination as to the difference between grading and excavation and development of driveways and house sites. That's it. And if there's any of that, then we're really in a situation where judgment calls are being made about the difference between grading and excavation on the fly later down the road. You folks can be confident from what staff said here today and what they said in their critique of our 3-page expert evidence about foundations and driveways being excavated and not graded. You can tell from what staff said that, you know, they see excavation and grading much differently than the applicant does. They apply different working definitions to those terms. And if that's the case, then the whole issue of grading 20% slope should be off the table. Interestingly enough, the city knows this is a bad criteria. We included in the record the entire latest draft of the tune-up of the clear and objective standards, and the 20% grading limitation is out because it's such a dumb standard. So it may be the easiest thing for you to do to get rid of it right now in the context of a site-specific decision, because the distinction between those two terms is ambiguous, because everybody goes to their dictionaries and looks for definitions. And even when they have the definitions, you know, you're still arguing about what's what, and that's not okay. Thank you.
So at this time, I'm going to close the public hearing and the record. I do want the staff, I say in the record because the applicant wanted some time to respond. So is that, respond to what was submitted today and had requested that?
The applicant does have the ability to raise procedural objections at any point during the process. And so staff will accept that and either provide it directly to you or kind of walk you through it. The record, it's a good question, but I think the record is, I would recommend closing the record to new testimony at this point. But.
Okay. So will, in them responding to the items submitted tonight, is that considered new evidence? Is that, or procedurally that is acceptable after the record is closed?
I assume the applicant will be very careful about not raising any new evidence in their procedural objections.
Okay. So are there any questions from Planning Commission? Yeah, Commissioner Baker.
Well, I was just going to suggest, since the applicant suggested, you know, being flexible about the time for a decision beyond the 120 days, that one way to handle this would be to leave the record open so that the applicant could review this information. Or have we already officially closed?
Well, thank you, Commissioner Baker. So I'm going to defer to staff's recommendation, to Lauren Summers' recommendation. It sounds like it isn't new evidence, so it sounds like it's not new evidence. And
so Commissioner Baker is correct. I mean, up until the applicant's final rebuttal, I think I was operating under the assumption that the 120 days ran on July 6th, and so there would not have been enough time to leave the record open, given your deliberations are set for next Monday and Tuesday. It sounds like now the applicant may be willing to offer an extension of the 120 days, which would allow for leaving the record open for more purposes for some period of time, but I didn't hear a specific time period being offered by the applicant. So.
Yeah, I didn't, so here's the position, this is what, and I just want to check with you. It doesn't sound like there have been any other requests to have the record stay open for additional testimony. And if this is not considered additional testimony, as you're saying, so if there's some kind of a difference between the two, I'm going to rely on your judgment in terms of if the record's closed and they can actually accomplish what they want to. I'm not sure it's needed as long as it procedurally is correct.
This is an issue that I haven't looked at in a little while, but my understanding is that the parties have the opportunity to make procedural objections throughout the process. I understand that the applicant is not offering new evidence, nor do I expect that they would be making any arguments about any of the approval criteria. My understanding is the submission is limited to a discussion of what they believe was new evidence that was presented tonight and/or arguments that are outside of the appeal issues that they're making an objection to allow Planning Commission then to decide whether or not to reject that information.
Okay. So.
I move to close the record.
I second.
Okay. Discussion. Thank you.
I think based on what you just summarized, that what he wants to provide is procedural and it's not new testimony, so.
Perfect. Commissioner Baker.
I just want to clarify that that would allow anyone with procedural issues to submit information to the planning department, not just the applicant.
Sounds like that's consistent with the.
That's true, although I would clarify again that what we're talking about is not new evidence, not arguments about the approval criteria or the applicability thereof, but simply if anyone has objections that any of the discussion items tonight were either new evidence or not related to appeal issues raised by the applicant, they could let us know about that.
Perfect. Okay, any more discussion items? Okay, let's take a vote. All those in favor of the motion? Okay, it's unanimous. Thank you. So it sounds like the Planning Commission, our deliberations are June 24th at 11:30 a.m. and June 25th at 5:30 p.m. in the Sloat Room of the Atrium Building. Planning Commission, do you have any items that you want staff to follow up before deliberations? Commissioner Borowski.
Yeah, but before that, I just wanted to kind of make a statement to the people who came and testified. Thank you all for coming out. I appreciate it. For some of you who have delved into the planning process for the first time, just let it be known that we're just like you guys. We're citizens. I'm not a planner. I am a restaurateur and a cook. We have a school teacher on our commission, so we aren't lawyers. We're not paid planners per se, and so we're going through this as well. We take it and look at it, and we're trying to look at it through your lenses, but also through the lens of what the code says and what the law says. So there have been many times in my position as a planning commissioner where I have had to look at and make a decision and say, you know, if my house were right next to this, I would feel bad about the decision that I'm making, but I'm forced to kind of by the way the codes and the laws are written. So just let that be known that that's out there. As far as things from staff, you know, a couple of these appeal issues, to me, seem like they're above our pay grade. They seem to me like they're decisions that need to be made at the Land Use Board of Appeals. And I'm talking about the 900-foot and whether or not this property is an applicable property to the South Hill study. We've seen that before. I thought it went to LUBA and was adjudicated, but it sounds like from what the testimony of the applicant was, it wasn't adjudicated. I don't know if I feel comfortable adjudicating that at a local level, but it sounds like I might have to. So that's one of the things that definitely I'm going to want to have as much information about that issue as I can. The applicant made some assertions about the annexation rules and those types of things. If you could let us know where those are in the record, that would be helpful so that we can, so I don't have to dig through the 1,142 pages to find it. As far as grading and excavations goes, that one's pretty fresh in my memory. It wasn't too long ago that we made that decision. And unfortunately, kind of like what one of the people testifying said, when we make these decisions, it trickles downhill and it goes into other decisions. And so I don't know if this was, when we made that last decision, I don't know if I had anticipated seeing this brought to us in this type of form. So I will be going back and reading that decision. Actually, I've on the back of my package, the last page has my signature on it because it's the Capitol Hill PUD approval. So I'm very familiar with it. But again, thank you to all of you for coming out.
Commissioner, are there any other commissioners that have questions for staff or follow-up? Commissioner Fraga.
So thank you very much to everyone who came out and spoke tonight. As Commissioner Borowski said, some of us are not experts in these areas either, so I appreciate very much the learning curve that's present. But some of the issues that were expressed by the community, I do think are able to be addressed around something that is the focus, and that is the open common space issue that we're deliberating. And so I guess my question to staff is around when we think about whether we're approving or not approving or amending that appeal, is it outside our scope to amend in a way that looks at the staff's original conversation, right? That goes back to some of the conversations that I believe we've had about open space that recognize the value of it being accessible and being unobstructed. So I would want information addressing that. And then I guess going to the question of the status of Lot 36 in the future, I would probably want to have some information around what happens when our new clear and objective standards go into effect, and PUDs that we've already looked at, then do they have an opportunity to then go back and ask to use the new code? I mean, what does that look like? So that's all. The new clear and objective standards are pretty fresh in our heads, and so we know some of the overlap here. And so what would that relationship be in the future related to how Lot 36 would be impacted?
Any other follow-up items, Commissioner Edwards?
Thank you. I just had one question because I heard two different things with regards to the open space. When you were presenting, you mentioned something about the property lines where fences could separate or whatnot, and then the applicant did make a comment about how those areas would it be intended to not have any structure on them. And so I just wanted a clarification as to what would be allowed on open space? Or is that just subjective? So I just don't know if that's something that's clarified. Because you said that there could be fences, and then the applicant had said that there wouldn't be any structures. So I just wanted to clarify what is just theoretical or what is actually may or may not be allowed. Does that make sense?
Yes. You want that now?
No, just for deliberations, because I would just like clarification.
Commissioner Baker.
Yeah, a couple of things. Since we have the building department here, I think it would be helpful to know what building code we're operating under, and if the definition from that would be considered, part of the Eugene code, if there were definitions in there for grading and that the current code we're operating under, would they be considered, again, like our adopted standards? So, but it would be useful to know that, what building code we're operating under if it's not the one that was cited by one of the speakers tonight. The other question I had was about the needed housing has a requirement for the common open space to be in 3 contiguous areas. I mean, we've seen this before in other PUDs we reviewed. So if you could bring back information about whether the plan meets that criteria, as well as the common open space, whether it's in 3 contiguous areas. Because the drawings are a little confusing in that regard. And I'll leave it at that. Oh, and just a general comment. I assume you're going to be going through all of the testimony you received and telling us about anything that was not previously in the record.
That is correct.
Great.
Okay.
About one more.
Yes, Commissioner Borowski.
So several of the applicants' appeals issues hinged on whether or not parts of the code were clear and objective. And we've seen that before. We saw it before on the 19-not rule, but we saw it on other appeals that I've seen that I won't cite. Well, actually, they are in the record. One of them was cited in the record, the Capitol Hill. As of right now, if it's in the code and it hasn't been remanded by LUBA, it is considered to be clear and objective, is my understanding. So if there can be some sort of a memo on that as well, because several of his appeal issues were, if this, then it's not clear and objective. And to me, I don't believe that that's within our purview. It's been my that's kind of what I've been understanding, but I also would like some sort of, I know that that's going to be part of the deliberations, and so if legal can come up with a memo for that as part of our AIS, or be ready to brief on that when we're ready for deliberations, because if that's lined out, I think we can go through several of those. If this, then it's not clear and objective. Again, those were ones that seemed to me that they were above my level of adjudication, so that would be helpful. Thank you.
So before we continue, do you have any questions for us? And then I'll let Commissioner Baker. No? Okay, Commissioner Baker.
Yeah, there's one other thing, because this appeal issue's up here. If the staff could could clarify why they wanted the language changed the way they did. Again, I don't just looking at it now without reviewing it in detail, if you could sort of make a better exposition for us when we meet next time on exactly why condition 3, this recommended change occurs. And there's probably some good reasons. I can see some myself, but I just want to get a better perspective on why staff changed the wording the way they did, and better understand that, because that would be one thing that we would have to consider during these deliberations.
Okay. So I'm going to, first I want to say thank you for everyone that showed up today. I know that my other planning commissioners and myself have already expressed our planning process is complex, and I appreciate that you stayed with it and communicated with staff and that you're here tonight. That's a big part of the process, so I appreciate it. And definitely come. There won't be opportunity for more testimony, but you're welcome to come to the deliberations and be there in person to listen. They are also recorded, and you can watch them. Yeah. Okay, I'm going to close the meeting. Thank you.